Losing a loved one is one of the most profoundly difficult experiences we can face in life. In the midst of overwhelming grief, the emotional weight is heavy enough to bear on its own. Yet, almost immediately, grieving families are often thrust into a labyrinth of practical and unfamiliar legal responsibilities. One of the most significant of these hurdles is probate court. Our goal today is to provide you with a clear and compassionate overview of this process, helping you navigate the legal steps ahead. Please remember, this video provides general information and is not legal advice. For specific guidance, always consult a qualified attorney in your jurisdiction. When a loved one passes away, you might hear the term probate thrown around. But what exactly is probate court? Simply put, it is a specialized legal court responsible for overseeing the administration of a deceased person's estate. Its primary purpose is to ensure that assets are distributed fairly, legally, and according to the person's wishes or state law. The probate process involves several key functions. First, the court is responsible for validating the deceased's last will and testament, ensuring it meets all legal requirements. If the will is valid, or even if there isn't one, the court officially appoints an executor or administrator to manage the estate. Once appointed, the executor's job is to identify and calculate the value of all assets, from real estate to bank accounts and personal belongings. But before anyone inherits, the estate must settle its obligations. The court oversees the payment of outstanding debts and final taxes using the estate's funds. Finally, after all debts are cleared, the remaining assets are officially distributed to the rightful heirs. Throughout this entire process, if family members or creditors disagree, the probate court steps in to resolve disputes fairly, ensuring peace of mind during a difficult time. A common question many ask after losing a loved one is, does every estate have to go through probate? The short answer is no. Several key exemptions can help bypass this lengthy process, saving you time and money. First, many states offer a simplified process for small estates. If the total assets fall below a specific state threshold, survivors can often skip formal probate by completing a small estate affidavit. Second, assets held in a living trust bypass probate entirely. Because the trust legally owns the assets, a trustee can distribute the property directly to heirs without any court intervention. Third, jointly owned property often includes a right of survivorship. When a co-owner of a house or account passes away, full ownership automatically transfers to the surviving owner. Fourth, payable on death or transfer on death accounts. These specific designations allow your bank or brokerage funds to transfer instantly and directly to a named beneficiary outside of probate. Finally, assets like life insurance and retirement accounts have built-in beneficiary designations. Payouts go directly to family members, providing immediate financial support during difficult times. Let's walk through the probate process, step by step. We'll follow a typical timeline, starting with Step 1, filing the petition. This officially opens the case with the probate court and submits the will, if one exists, to begin the legal proceedings. Step 2 is providing notice to heirs and creditors. The court requires that all potential beneficiaries and anyone the deceased owed money to are properly notified, often through both direct mail and local newspaper publications. In Step 3, the court officially appoints the executor or administrator. A judge signs the order, and you receive letters testamentary, the crucial document granting you the legal authority to act on behalf of the estate. Step 4 is the inventory and appraisal of assets. Armed with your legal authority, you must meticulously identify, secure, and value everything left behind, from bank accounts and real estate down to specific personal property. Step 5 covers the payment of debts and taxes using estate funds. Alongside this is Step 6, accounting. The executor must keep a strict, highly detailed record of every penny coming in and going out to eventually present to the court. Step 7 is the distribution of assets. Once all obligations are met and the judge approves your accounting, funds and belongings are transferred to the rightful beneficiaries. Finally, in Step 8, the court issues an order closing the estate. Throughout this journey, keep an eye on strict timelines. Expect rules like 30 days to file the will, 3 to 6 months for creditor claims, and 9 months for federal estate taxes.
Probate is not just time-consuming. It can also be expensive. When you open the estate ledger, the most significant expense is often attorney fees. Hiring a lawyer is highly recommended, but takes up a large portion of the budget.
Executors are also entitled to compensation based on the estate's value, though family members often waive this fee. You will also need to cover standard court filing fees. If the estate includes real estate or valuables, you must hire professional appraisers to accurately assess their worth. Courts sometimes require a probate bond to protect the estate assets. Also, be prepared for miscellaneous expenses, like ongoing utility bills for the deceased's home, publishing mandatory legal notices in newspapers, and the costs of preparing a property for sale. While probate is a standard legal process, it is often lengthy and public. Fortunately, with proactive estate planning, you can minimize or even completely avoid it. One of the most effective tools is a living trust, which holds your assets and transfers them directly to your heirs. Similarly, holding property in joint ownership with right of survivorship ensures it passes automatically to the surviving owner. You can also use payable on death or transfer on death designations for bank accounts. By naming direct beneficiaries on your life insurance policies and retirement accounts, those funds bypass probate entirely. Additionally, gifting assets during your lifetime reduces your taxable estate. And if you have a smaller estate, many states offer simplified probate procedures, saving your loved ones significant time and money. Navigating the probate process alone can feel overwhelming while grieving. Seeking expert guidance is one of the best steps you can take. Consulting an experienced probate attorney helps you avoid costly mistakes and handles complex paperwork efficiently. Your local probate court is a vital starting point. You can often find court-approved directories online. Navigating to state and county-specific portals gives you direct access to local court procedures, filing fees, and contact information tailored to your jurisdiction. Don't hesitate to lean on additional resources. Your state bar association can provide vetted referrals, and legal aid organizations offer assistance if finances are tight. Educational books and official government websites with downloadable forms also provide clarity, empowering you to move forward confidently. Executor versus administrator. An executor is named in a will. An administrator is appointed by the court when there is no will. How long does probate take? A simple estate might close in a few months, while complex ones or disputes can stretch into years. What if someone dies without a will? This is called dying intestate. State laws decide asset distribution, typically starting with a surviving spouse and children. Can you contest a will? Yes, but you need legal grounds like undue influence or lack of mental capacity, not just disappointment with your share. What is a small estate affidavit? It is a simplified process for estates with limited assets, letting heirs claim property without full formal probate. Do you need a lawyer? It is not always required, but an attorney helps navigate complex filings and strict deadlines, avoiding costly mistakes. We sincerely hope this guide has brought you some clarity and support during a challenging time. If you found this information helpful, please consider giving this video a like, subscribing to our channel for more valuable content, and sharing your thoughts or questions in the comments below. For further resources and assistance, remember to visit us at funeralist.com.